Hello and welcome to class. Let's begin right away. Thank you for being here.
You don't like the lights, but it's camera time. Said take the picture, but you rolled your eyes. Now I'm mortified and still terrorized. Push me behind to get me from my better side. I wanna push you back, but that's all you want. Wanna rub me up, I'm holding back.
Clerk and Lindsell on Torts 20th ed. Main Volume. Chapter 22, Defamation. Section 9. Damages. Subsection, E, Mitigation of Damages. Subsection, 2, Background Context. Directly relevant background context. 22 to 239. It is often the case that the partly true information is clearly insufficient to justify the defamatory allegation, even taking into account S.5. A defendant can only advance a defense of justification where he has a realistic prospect of winning the case. It cannot be used simply to mitigate damages. 1042. The problem for defendants is how to get the partly true material before the jury. For many years the so-called rule in Scott v. Sampson has been understood to act as a prohibition on allowing a defendant to rely on acts of misconduct, which do not form part of a defense of justification, solely in order to mitigate damages. The rule has been the subject of considerable criticism on the basis that it allowed unsavory claimants to be overcompensated. The draft 1996 Act included a section to allow such evidence to be adduced in appropriate circumstances. The section was dropped at the committee stage, it having been suggested in parliamentary debate that its inclusion would be a muckraker's charter. 1043. However, the effect of the rule has been much reduced by the Court of Appeal decision in Burstein v. Times Newspapers Limited 1044. Even taking into account S.5. A defendant can only advance a defense of justification where he has a realistic prospect of winning the case. It cannot be used simply to mitigate damages. 1042. The problem for defendants is how to get the partly true material before the jury. For many years the so-called rule in Scott v. Sampson has been understood to act as a prohibition on allowing a defendant to rely on acts of misconduct, which do not form part of a defense of justification, solely in order to mitigate damages. The rule has been the subject of considerable criticism on the basis that it allowed unsavory claimants to be overcompensated. The draft 1996 Act included a section to allow such evidence to be adduced in appropriate circumstances. The section was dropped at the committee stage, it having been suggested in parliamentary debate that its inclusion would be a muckraker's charter. 1043. However, the effect of the rule has been much reduced by the Court of Appeal decision in Burstein v. Times Newspapers Limited 1044. In that case the claimant was the subject of a diary piece which stated, "The music is by Keith Burstein, an aggressively rather slushy composer who used to organize bands of hecklers to go about wrecking performances of modern atonal music, particularly anything by Sir Harrison Birtwistle." The claimant had not wrecked any performances. However, he had been associated with a group called the Hecklers which had encouraged people to boo at the end of a different performance at the Royal Opera House. Although the claimant had, page 194, not personally encouraged this, he had attended the concert and joined in some light booing at the end. In subsequent publicity he had referred to his involvement with the Hecklers. The defense of fair comment was struck out and the defendants then sought, in Mitigation of Damages, to reintroduce the factual matters originally intended to underpin the fair comment defense. The trial judge refused to allow this, and the jury assessed damages without any direct reference to the claimant's involvement with the hecklers. The Court of Appeal overturned the judge's ruling, and stated that the rule in Scott v. Sampson does not prevent a defendant from drawing the jury's attention to directly relevant background material. It was wrong for the jury to assess damages in blinkers. The extent to which background evidence is admissible was a case management decision for the judge, taking into account the factors outlined in the CPR's overriding objective, in particular, proportionality. Admissibility of Burstein evidence. 22 to 240. The extent to which background evidence is admissible will generally be a debatable issue. 1045 As stated by May L.J. in Burstein, it will, generally speaking, normally be both unfair and irrelevant if a claimant complaining of a specific defamatory publication is subjected to a roving inquiry into aspects of his or her life unconnected with the subject matter of the defamatory publication. Clearly, the greater the proximity of the material to the libel, the more likely its inclusion. Inclusion. In Carpenter v. Associated Newspapers, Newspapers Ltd. 1046, the claimant was accused of having made embarrassing sexual advances to a married man. The court held that applying the Burstein principle, the defendant should be permitted to adduce evidence of the claimant's previous relationship with another married man. In contrast, in Ganacci v. Howney Ltd. 1047, the claimant was accused of having close links to a terrorist organization. Organization. Initial defenses of justification and qualified privilege were abandoned. However, in Mitigation of Damages, the defendants sought to rely on the following: public pronouncements by the claimant made 10 or more years previously, aspects of the history of a political movement headed by the claimant, including allegations made by former leaders of the movement that he had chosen to resort to violence, the claimant's connections with the Sudanese regime, which offered him a diplomatic passport shortly after providing asylum to Osama bin Laden, and his connections with another alleged terrorist. Permission to rely on these points was refused. The judge acknowledged that the claimant should not put himself before the jury in a false light. However, he considered the issue to be whether the Burstein principle permitted the defendants to put forward directly relevant background context in circumstances where they had abandoned defenses of justification and qualified privilege. They could not, because this would amount to allowing in aspects of the defense of justification by the back door. Further, none of the particulars put forward could properly be described as directly relevant background. They had not been included in the article complained of, for example. 1048. In Hunt v. Evening Standard Ltd. 2011 EWHC 272, QB, Tijandat J refused to strike out a claim of general bad reputation in respect of the claimant, who was alleged to have such a reputation for being the head of an organized crime group and for violent, criminal behavior. The decision to allow such evidence was in part based on the fact that the claimant had in his particulars of claim made the allegation that he had a good reputation, which permitted the defense to challenge such a claim. This was also in line with the liberal approach proposed by the Court of Appeal in Burstein v. Times Newspapers Limited 2001 1 WLR 579. 1045 in Warren v. Random House Group Ltd 2008 EWCA Civ 834, 2009 QB 600. The defendant sought permission to introduce certain matters in mitigation under the Burstein principle following the making and acceptance of an offer of amends. Permission was refused because the particulars were an attempt to introduce by an indirect route material which amounted to a plea of justification. This was not permissible in a case where the defendant had made an offer of amends as well as a public apology to the claimant. 1046 2001 All ER, D, 445, Nov, QB. 1047 2003 EWHC 552, QB. 1048 See also Turner v. New. News Group Newspapers 2006 EWCA Civ 540, 2006 1 WLR 3469, where the Court of Appeal stated that evidence would only be admissible under Burstein if it was so relevant to that part of the claimant's life over which complaint was made that there was a real risk of a jury awarding damages in blinkers if they were not aware of the evidence. Main Volume. Chapter 22, Defamation. Section 9. Damages. Subsection E. Mitigation of damages. Section 9. Damages. Subsection E. Mitigation of damages. Subsection 3. Conduct and reputation of claimant. Conduct of the claimant. Claimant. 22 to 241. The conduct of the claimant is a relevant factor in the assessment of damages. 1049 Conduct in this context is limited to the claimant's acts and omissions at the time the material is published and in the course of the litigation. It follows from general principles that a claimant must take reasonable steps to minimize the loss from the unlawful act. Delay in making a complaint can contribute to the injury to reputation, and would also suggest that the claimant has not been injured by the publication. This is particularly a factor where the defendant agrees to apologize as soon as the matter is brought to his attention. Where the defendant seeks to defend the action, the delay on the part of the claimant may have less effect. There may be occasions where the claimant has to a certain extent provoked the defamatory statement, but the strict requirements of the defense of consent are not met and the defendant cannot rely on a reply to attack. Qualified privilege. The claimant's conduct can nevertheless mitigate the damages. Damages. In Gorman v. Mudd 1050, Russell L.J. felt that the claimant took part of the blame for the unseemly quarrel that developed between her and the defendant. In Godfrey v. Demon Internet Ltd 1051, the defendant sought to rely on allegedly inflammatory internet postings by the claimant which, it submitted, were intended to provoke people into libeling him. There must be a direct correlation between the provocation and the libel. In Burstein 1052, the Court of Appeal rejected the defendant's primary submission that the claimant had provoked the libel. The claimant in Trum v. Norman 1053 would have been awarded £15,000 in damages but for the fact that he had published on his website Page 196. Comments that were unnecessarily provocative and offensive and which led to the publication of the allegations of which he complained in the proceedings. Damages were reduced to £7,500. The fact that the allegations have been published previously and the claimant has not taken any action is not to be taken into account 1054, nor that he has omitted to complain about other defamatory parts of the publication in question 1055. In any event, the failure to complain may be the subject of cross-examination as to credit. 1056 Misconduct in the course of the litigation is also admissible and, where serious, can lead to a dramatic reduction on the damages awarded. In Campbell v. News Group Newspapers 1057, the Court of Appeal considered that it would be an affront of justice if a claimant's own disreputable conduct had to be ignored in assessing the damages. In that case, it was found at trial that the claimant had procured witnesses to make false statements, attack the credibility of a wholly innocent witness, and accused one of the defendant's lawyers of the most serious professional misconduct. The Court of Appeal considered that the claimant had acted in this way specifically to improve the outcome of the litigation itself. In the circumstances, a jury award of £350,000 was reduced to £30,000. Bad reputation of claimant. 22 to 242. A claimant who brings an action of defamation puts his reputation in issue, and the defendant in mitigation of damages may give evidence that the claimant bears a bad character. The word character is not here used in the sense of a man's quality of disposition but in the sense of the reputation which he bears. The action for libel is an action for loss of reputation. On the issue of reputation, what has to be investigated is not whether the claimant is in truth a good or bad man, but whether he is reputed to be a good or a bad man. 1058. If he has no reputation to lose, attacks on his character cannot really have injured him and cannot therefore entitle him to substantial damages. 1059. The law distinguishes between a claimant's actual reputation and the events in his life which determine or ought to determine his reputation. Subject to limited exceptions, only where the defendant establishes that the claimant has, in fact, a bad reputation will the damages be reduced from what might otherwise have been awarded. It is not permissible to demonstrate that the claimant would have a bad reputation if his past conduct were generally known. It follows that in order to establish that the claimant has a bad reputation, the defendant must call witnesses who are limited to stating that the claimant has a bad reputation. They cannot, generally, refer to the particular incidents in the claimant's life which have given rise to the bad reputation. 1060. Furthermore, in order to mitigate damages, the claimant's bad reputation must relate to the sphere of his life to which the defamation is directed. 1061. It is recognized that a person may have a good reputation in relation to certain matters and a bad reputation in relation to others. As the law stands, it would not be inconceivable for Hitler to allege that his bad reputation should not mitigate an allegation that he was unfaithful to Eva Braun, bearing in mind that he did not have a reputation for sexual misconduct. In such a case, the defendant would have to rely on the common sense and decency of a jury. In Goody v. Odham's Press 1062, the Court of Appeal recognized that criminal convictions are an exception to the general rule. They are the raw material upon which bad reputation is built up. They have taken place in open court. They are matters of public knowledge. They are accepted by people generally as giving the best guide to his reputation and standing. 1063 Criminal convictions are therefore specific acts of misconduct which can be relied on as evidence of general bad reputation. The conviction must be in the same sphere of the claimant's life as the defamatory statement and have taken place within a relevant period so as to affect his current reputation. In Mitchell v. Evening Chronicle 1064, the claimant was in prison for serious crimes. The defendants published, page 197, an article about racists in the Northeast in their newspaper and included in it a photograph of a person other than the claimant but with the claimant's name and address. The defendants accepted that the article did not apply to the claimant and applied to strike out his action or to have summary judgment. They argued that he would have no real prospect of success, and even if he were successful, he would get only nominal damages as his reputation was so bad. They also stated that they would plead qualified privilege. It was held that, although the damages would be small, the claimant should still be allowed to pursue his claim. There have been some unreported cases where the principle permitting reliance on criminal convictions was extended to findings of civil courts which were adverse to the claimant. In one case, a judge refused to strike out at an interlocutory stage an allegation that a widely reported finding of the Football Association in relation to allegation that a claimant criminal there have been some unreported cases where the principle permitting reliance on criminal convictions was extended to findings of civil courts which were adverse to the claimant. In one case, a judge refused to strike out at an interlocutory stage an allegation that a widely reported finding of the Football Association in relation to irregular payments to players was evidence of an alleged bad reputation. In another, the defendant sought to rely on adverse findings against former Sun editor, Kelvin Mackenzie, by the Press Council and the Press Complaints Commission, as evidence of bad reputation. The matter was never tested. 1060. Section 9. Damages. Subsection E. Mitigation of damages. Subsection 4. Other publications. Publication. Other publications. Publication of same libels elsewhere. 22 to 243. A defendant cannot mitigate the damages by producing evidence of other publications to the same effect as his, nor can the damages be mitigated by the other prior or concurrent publications being in any way regarded as having tarnished or impaired the defendant's reputation. 1066. Damages recovered for similar libel. 22 to 244. Section 12 of the Defamation Act 1952 provides, in any action for libel or slander, the defendant may give evidence in mitigation of damages that the claimant has recovered damages, or has brought actions for damages, for libel or slander in respect of the publication of words to the same effect as the words on which the action is founded, or has received or agreed to receive compensation in respect of any such publication. 1067. In such cases, for example where the similar libels are published in two national newspapers on the same day, the jury ought to be directed to consider how far the damage suffered by the claimants can reasonably be attributed solely to the libel with which they are concerned, and how far it ought to be regarded as the joint result of the two libels. If they think that some part of the damage is the joint result of the two libels, they should bear in mind that the claimant ought not to be compensated twice for the same loss. 1068. It must be remembered that everybody concerned with the uttering or publication of defamatory matter, for example proprietor, editor, printer, or seller of a newspaper containing such matter, may be sued, and that such actions will be governed by the Civil Liability Contribution Act 1978. 1069. Section 11 of the Defamation Act 1952 deals expressly with agreement for indemnity as follows: an agreement for indemnifying any person against civil liability for libel in respect of the Publication of any matter shall not be unlawful unless at the time of the publication that person knows that the matter is defamatory, and does not reasonably believe there is a good defense to any action brought upon it.